It is exactly 7 p.m. Central Standard Time. Today is Monday, November the 1st. November the 1st. And welcome to week number 5. Week number 5. Today, as you know, we will be, good evening. Um, I'll take the God evening as well. A lot of people missed that extra O, but that's okay. It's still good. Now, I want to remind you that we're going to go until our normal time, and then we're going to take a half-hour break, and then we're going to come back at 8:30. And the reason for that is then we'll be talking about um, week 6 at about 8 o'clock my time. The announcement for week 6 will be posted. I already sent you the PowerPoints for both weeks 5 and 6. So we are going to go on from there. Okay. So let me share my screen. And share it this way. So the first thing I want to say is that several of you had some issues with week number 3's written assignment. And you know who I'm talking about, and I gave an opportunity to resubmit the assignment by yesterday at 11:59 p.m. Central Standard Time. And the other issue with that was many of you forgot the point that I always make, and that is to cite the official court cases in that written assignment for week number 3. You had them. They were already given to you, and some people didn't do that. Only a few of you guys did it, but I want you to know that I always stress in all of my classes that you want to use the official court cases to the extent that you can find them, especially when they're United States Supreme Court cases. So you could lose points. You lost points for that. That's for those scenarios that with the exclusionary rule. But I gave you cases even weeks before relating to the exclusionary rule, and then we talked extensively about that during week number 3. So just make sure you pay attention to those kind of things. And it was also in the rubric. The rubric said that there were people who wrote the scenarios out, but they never mentioned any cases to support it. And very, very, very big mistake, because this course is top heavy with case law on the topics that we deal with. So let's go ahead and just get started. Again, let's take a look at our calendar here. That is the month view. And this is where we are now. We are in November, and your live lecture, both week 5 and week 6, remember at 8:30. Your initial post is due on Tuesday. Your reply post is due on Saturday. And then your written assignments are due, okay, for week 5. All right. And the course ends on the 9th. just to remind some people who wonder why are we having 2 lectures, is because it wouldn't make sense to have a week 6 lecture on the 8th. It would not be beneficial for you. So that's why we're doing this. All right, to give you plenty of time during the week to be ready for that. Okay, let's go to the announcement. Again, you see week 5, it's an announcement. In this week, the 6th Amendment and government authority will be presented. You had chapters 10 and 11 of the text, and you're going to deal with the 5th Amendment, obtaining legally the 6th Amendment right to counsel and fair trial. The scope of the right to counsel, we'll talk about that. Speedy trial, 6th Amendment trial rights, and then the knowledge check. Then there's some things in here, the teaching of the 5th of Miranda versus Arizona. As you know, we talked about this quite extensively, and then I told you about my history relating to Miranda and my former law professor who had the things that were used by the police department to question him. And then these are the Miranda rights that came about as a result of that. We've been discussing this. It's a good article. Take time to read it. And it's very important. And you know, the thing about Miranda, a lot of people don't know, is that it was not just one case. It was, as it says here in here, 4 cases that were all involving the same thing. Okay. So remember, the Supreme Court based the need for this protective rule on the nature of modern police interrogation. Modern police interrogation practices are psychologically rather than physically oriented. And that has something to do with the thing. So take a good look at this article. This is an excellent piece. This is a whole lesson that they had on it, but case studies and so forth. But I mean, this is excellent. This is an excellent piece. If I was, I would copy and paste this link and make sure that I copy and paste that link and save it. So revising the right to a speedy trial, we're going to talk about the Speedy Trial Act and the 6th Amendment, and right to counsel. Those are the 2 issues that are primarily the topics of discussion today. And so I've already told you what the reading was all about up here. So you're going to deal with the discussion assignment, right to an attorney, and you know the deadline, and then the written assignment, the 6th Amendment, and trial rights. Okay, and then you know about my motto down here. All right. You know about the due dates on those things. All right, so let's get into the module itself. So let's start talking about the assignment. Let's talk about this first. I'm going to remind you, since you've been asked to create a 1 to 2 page flyer about the 6th Amendment, rights related to counsel speedy trials, and basic trial rights. First, locate your state's rules of criminal procedure. Every state has a criminal procedure, every state. And you could find it easily. Next, so what you're going to do is create a 1 to 2 page flyer that explains what the right to counsel is all about. Discuss the requirements of a speedy trial and the common time frames from arrest, initial appearance to trial. Explain the role of the criminal complainant and the indictment that's filed. Discuss valid reasons for the confrontation clause. You have to know what that is, but you will know. And you should know if you're doing the reading. Analyzes the scope of permitted media access to trials. APA, you see that? It means what it says. Cite your sources, credible sources. And you should always recognize that the credible sources that are really the most powerful ones in these constitutional issues are the cases, the Supreme Court cases, and the leading case in this area. Does anybody know the leading case in the Sixth Amendment right to counsel? Anybody know the name of it? I've referred to it before. That's part of it. That's the first part. That's the name of the person, that one of the parties involved. And it was Gideon versus Wainwright. And that's the case. And make sure you cite that case in your assignment. Did you hear me? And you'll have the official court citation in your readings and in the lecture. All right. Very important. So identify the state that you're using for your flyer, as well as the rules and the identifiers depending on how your state classifies the rules. Okay. It doesn't have to be your state. It could be any state. But best if you start to use the state that you're in or that you plan on working in to get that information. Okay. And this tells you how to deal with a flyer. Remember one thing. Your flyer, even though it doesn't say here, it should be in a form that I can check for Grammarly. And the only one that I can check is a Word document. It's a Word document. Normally they drop that in here, but they didn't do that. But you can make sure that you do that. Do not do a PDF. Do not do a publisher. Do not do a PowerPoint. Okay. You've done flyers before, and you know that you can do them that way. All right. So now let's look at the rubric. And again, I'm only going to concentrate on mastery because that's the one that I teach from. Okay. So you're dealing with the right to counsel. Outstanding explanation of when the right to counsel applies to those suspected of criminal behavior with comprehensive details demonstrating a thorough understanding of the right to counsel. Then the other issue is speedy trial. Same thing, using speedy trial. The third topic is explanation of the role of the criminal complaint and the indictment or information filled with comprehensive details indicating an understanding of it. The confrontation clause. outstanding discussion of valid reasons for the confrontation clause. And again, we'll talk about that. Media access, outstanding analysis of the scope that media is involved. And then, as I said already, credible sources, your APA format. You already know when I say APA format, it's not just references. It's not just citations. It's citations and references. Okay. And then professional language should be a 1 to 2 page flyer with no spelling, grammar, and punctuation errors. And that's it. Any questions? No questions? Okay. All right. Just remember, it's a Word document. People that do it in a PDF, that means that they either didn't listen to the lecture or they did it before the lecture. But I mean, since it's Monday, you get yours, you got an advantage, you get a jump start, and you have the whole week ahead of you. All right, so that's the written assignment. I'll fill in some stuff when I talk. The discussion topic is the right to an attorney. For this, you'll apply the right to an attorney to this scenario here. And you'll use these facts, which I'm not going to go over. So in your initial post, discuss when the right to an attorney would and would not apply in this scenario. Discuss how to handle comments like, do you think I need an attorney? Or should I get an attorney? You'll know about that as we talk tonight. Discuss how the 2-week rule might apply to this scenario. Support your position with case law. Yeah, if you're going to do this again, I already gave you a case that fits in there. And then your reply post, you know, the procedures for that. Okay. All right. So nobody jumped on that one yet. But you want to get that done because the initial post is due tomorrow night. Live classroom submission link. So we're going to talk about the scope of the right to counsel, speedy trial, the Sixth Amendment trial rights. So let's start talking about the right to counsel. And you should be aware of the cases that affect that. So here's a nice scenario. It's a Friday evening and the court is not in session over the weekend. Arrest is made. You jail the suspect at 11 on Friday. When must law enforcement officers' report be completed? When does the suspect have to be brought in front of a judge? All of that you'll know. Must the suspect sit in jail over the weekend without judicial review? There's so many hours that you're supposed to do that. Answers to these questions are going to be covered before we leave here tonight. Okay. So you already know about Miranda and the right to remain silent. And then, included in that is the important aspect of what comes about, even though it's a Fifth Amendment case, the Sixth Amendment issue arises in the Miranda case, as you know, that you have a right to an attorney. And then to remain silent, you don't have to talk. Your attorney can speak for you. The answer is yes, you do. Do we really have the right to remain silent, though? You can speak if you want to. You can speak, but you have the right to remain silent, though. Why are you asking that question? I'm kind of puzzled. Yeah, but the answer is yes, we do. Now, when does the right to remain silent, Miranda, kick in? When does it? Anybody know? When is it mandatory to give it? It says, just like the right to remain silent, the right to an attorney applies when a person is in custody for a criminal offense and subject to interrogation. The right to an attorney is from the Sixth Amendment. Now, so the question is, do you have the right to remain silent even before you're in custody? Do you have that right? Anybody know? Based on the Fifth Amendment, it says you don't have to incriminate yourself. So, would it be wise for you to remain silent if a question is asked of you that might incriminate you? Come on, y'all too quiet. Anybody? We got the chat box out there. I don't see anybody typing or responding. Is the right to remain silent a constitutional right? Let me see. Maybe I'm not looking down far enough. Oh, okay. But oftentimes rights are overlooked. Hold it. Overlooked by who? Yeah, Chris, you're right about that. I have to scroll down here. When you are in custody, yes. Yep, yes, 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 yes. Everybody says yes. So you should be quiet. Here's the deal. The reason for it is the Constitution puts the burden of proof on who? Who has the burden of proof in a criminal case? The defense or the prosecution? Now, not in application. I know what you're thinking. The prosecution. That's the way it's set up. But in reality, in application, I've been a criminal defense lawyer many years. I know that it's actually the opposite in the minds of many triers of fact, including judges, believe it or not. But the point of the matter is that it's written that way. So what the law is that's written, such as the Constitution, doesn't necessarily mean that it's always applied. Now, no one can violate your right to remain silent because here's what happens. If they force you, beat you, I've had cases like that. We had a police chief Commander Burge. He's passed away. He was here in Chicago and he moved down to Florida and passed away some years later. But anyway, forced confessions out of people. So that didn't mean they gave up their rights, because they were coerced into it or forced into it. So just get that, make sure you get that. You are absolutely correct that it says, just like the right to remain silent, moving on to the attorney right, when you're in custody or under formal arrest or constructive arrest. In other words, you're not free to go. So the point of the matter is that if you're stopped by the police and they ask you your name, um, in many jurisdictions, there's laws that says you have to give them that information and that kind of stuff. You have to even have ID on you. So that's not a violation of just your name. It's not a violation of your right to remain silent. However, in terms of elaborating on circumstances, if you choose not to, then you can say, I don't want to talk. And they says, why? You're not under arrest. Says, well, I don't want to talk to answer the question, because it might incriminate that person. And so once you do that, they can't say, they can say you're not under arrest all the time. Remember what happened last week with that person who was talking, and then his mother came and said stop, but she couldn't do it. He was the one who had control over it. So it's that individual that has that control. So anyway, right to counsel is an important right, and law enforcement officers must properly apply it. Failing to properly recognize the right to an attorney can result in a statement being suppressed, which I have done many times. Evidence dismissed, and the guilty, the one who did the crime, is set free because of the exculpatory aspects of it. And remember the fruit of the poisonous tree, we discussed that as well. So we can't allow those kinds of things. So it's an individual right and has to be exercised by the suspect, just like the right to remain silent. It says reiterating questioning can't, unless the suspect recontacts the police and waives the right, or 14 days have elapsed between questioning or custody. There's the answer to the question earlier that you wondered about. Okay, so this is just an introduction to the scope. So the key thing that you want to focus on is that the person has the Miranda rights and the right to counsel generally when they are in custody. However, you can also, when you're not in custody, say, I don't want to talk and I want an attorney. Well, that's you basically saying, and then they start and say, why? We're just asking you some things. Says, I don't want to talk. I want an attorney. So what you're doing is you're bringing up the issue, and they can't make you talk. All right. Now, because here's what they do. If you refuse to talk, then what happens? And they want to keep you, then they have to do what? Tell me. Yep. Yep. That's right. And then right there we go. There you go. Now you're getting it. Yep. So it kind of makes, it's a little common sense things there that are involved there. So anyway, these are a few cases that you haven't heard of, but these are some good cases, especially this last one. Even though this one I have a little issues with because it's Louisiana. Louisiana deals with the Napoleonic Code, but it still deals with the Constitution. So, all right. So you guys got the flavor of what I'm talking about. So, but those are good questions. that you ask, because it prompts discussion. That's what I like. That's why when students come to lectures, they have an opportunity. You can't do that on the video. Let's talk about the speedy trial now. So, as you know, we've talked about the Fifth and the Sixth Amendment and the 14th Amendment. Remember, the Fifth and Sixth Amendment applied to the states because of the 14th Amendment. Okay, and there are processes that have to take place, hearings, such as it says here, lays out initial appearance, arraignment, or motion hearings. Now, usually your initial appearance is a bail hearing or a bond hearing within so many hours. I'm not going to tell you what that is, but it tells you. You will learn that. How many hours, and then you have an arraignment. At an arraignment, there's only two things that you do at an arraignment. You can only answer guilty or not guilty. Did anybody see My Cousin Vinny, the movie? You see that? Yeah. Those of you who saw it will remember in there that they had an arraignment, and his attorney, Joe Pesci, who really, he came out at the end good, but he was stumbling upon stuff. He didn't really know. And he really wasn't all that sharp. But here's what happened. When he stood before the judge says, Mr. Gambino, that was his name, Joe Pesci. He says, you are, he starts trying to explain his case. And the judge says, Mr. Gambini, you either have two choices. Either your client's pleading guilty or not guilty, one or the other. So which one is it? And then he reluctantly, because he wanted to get out the case. What he was trying to do at the arraignment is jump into a preliminary hearing mode where he was talking about the evidence to determine whether they had probable cause and those kind of things. So anyway, so you go through those and then you get to the motion hearings. That's where we start to file motions based on this motion to suppress, motion for psychiatric examination, and things of that nature. Motion for discovery, which is one of the earlier ones that you file because or as if you saw the movie again, in My Cousin Vinny, they refer to it as disclosure. And some jurisdictions do refer to it as disclosure. But they both mean the same thing. The disclosure means disclose to me. Discovery means the opportunity to discover. And so it operates the same way. So the right to a speedy and public trial is from, as I said earlier, the Sixth Amendment. In all criminal prosecutions, you'll have a right to a speedy and public trial by an impartial jury of the state and the district wherein the crime have been committed. Now, there's an exception to a public trial, and what is that? I think I mentioned that last week. Anybody remember? That's not open to the public. Which one is it? It's only one. Yeah, somebody said kid, but yeah, they mean juvenile. That's right. It's a juvenile. Yeah, that's it. Because you don't have the right to, uh, said kid, but I know you meant juvenile. Okay, same people, right? Except they don't refer to it as the kid trial. And to be honest with you, um, um, You said Khalif Browder didn't get his speedy trial. Okay, I don't know anything about that one, but I can tell you this: be aware that how speedy trial works, because we're going to talk about that right now. So let me explain to you how it works. Now, it can take a year for a person to get to trial, and to get from, as it says, from arrest to jury trial disposition takes an average of 9 to 13 months to and it sounds like every case violates the Speedy Trial Act. To ensure unreasonable delay, federal cases, this is the Federal Speedy Trial Act, and each state has their own. Let's see what you're saying. Oops, don't use that kind of language. Yeah, don't use that kind of language. Don't do that. The point of the matter is that here's I explain once you get into understanding speedy trial. So I'll go back to my point, is that the act requires an indictment to be filed within 30 days after that person is arrested. And the trial must commence or within 70 days and not less than 30 days from the indictment date. Requiring at least 30 days between indictment and trial commencement helps to ensure defendants are given adequate time to prepare for trial. Now, let me explain to you what happens. In practice, in reality, when we go to court, there is what we call demand for trial. And what happens is that, and incidentally, less than 10%, about 10% of the cases that are filed go to trial. Most of them are played out. So you all should know that already. I've talked about that before. And in reality, that's how it works. But these are the ones that do go to trial. Now, here's what happens. As an attorney, I'm not going to demand trial until I either get everything that I need to provide an adequate defense, or either I see that the prosecution is delaying it, and if delaying the information. And here's what happens. When you'll hear these words said, I've said them many times and people didn't understand why we were saying them. The speedy trial thing operates like a clock. It can start and it can stop. So let's say I come to court and I say, I'm ready for trial. I'm the defense attorney and demand trial. That clock is going tick, 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 tick. But let's say it comes to, and you'll have a date usually within 30 days. When you have that next court date and you come there and you get some information, and then you see it's some information that you need to do further investigation on, you're no longer going to demand trial. You're going to do what they call by agreement dates. So the defense and the prosecution can start and stop the clock. But the point of the matter is that the burden is on the individual. Now, I have had some colleagues of mine that got really jammed really big by trying to play the Speedy Trial Act game of Russian roulette. And the reason why they'll do that is that they believe that the prosecution is not going to be ready for trial within the period. The prosecution has and the defense generally, but especially the public defenders and the prosecutors have a little sheet, and they mark off how much time is left and dates. And both sides should be aware of that, because if it goes beyond the number of days, not where the delay was caused by the defense, but by the prosecution alone, then in that case, the defendant would say demand, they'd have already said demand trial. Every time the prosecution says something that they need more time to get such thing, the defendant's job is, okay, all right, and not by agreement. If you do it by agreement, then you're going to stop the clock from running. Okay, everybody kind of understand how an application that takes place now? Like, for example, we had 120 days or 90 days in Illinois, and it would take a year. Most of my cases took a year, but it's because of the time it took to get to trial. And while going through the motions that you're filing, then you're going to stop and start possibly the speedy trial clock. Everybody got that? You got it? Certain things can stop or start. You used COVID and said COVID did something to speedy trial. Yes, but did it do something adversely to the constitutional rights of the party? Because speedy trial does not stand on its own. As we delve into it, on its face, it's different from where it really works, as I've already tried to describe. So in the Ewell case, old case, 66, when I was still in high school, the justices said this is an important right, and you minimize anxiety and public concern. Individuals oftentimes are not able to make bail, and they stay in custody awaiting trial. So if the Speedy Trial Act, by the judge's count, is violated, then charges are dismissed. By the way, incidentally, COVID-19 actually changed the way that trials were conducted. There were places where they were held, but when those were not held, there was no system for starting and stopping because the attorneys weren't operating in that basis. And the bottom line was that it was an unanticipated catastrophe. So again, when you violate the Speedy Trial Act, a judge says that, whether it's a trial judge or appellate court judge or a Supreme Court justice. Okay. So look at what happened here in Dickey. It says state law enforcement was aware of Dickey's being in prison, but refused to provide him with a trial date. So what they were doing, they were delaying. Look who was delaying it, the prosecution, because he was in prison. That's not gonna fly. So the court said, no, you all should have brought this man to court. And so the charges were dismissed, the state robbery charges. So the key thing is, the final thing in this last paragraph is, in addition to ensuring a defendant's due process rights, because due process is the right to confront your witnesses, the confrontation clause, by the way, other reasons for speedy trial, that's the due process, for speedy trials, is in the interest of the public, for the victims, for the witnesses, and for everybody involved. That's what came about. That's how the Supreme Court, not the Supreme Court, the American Bar Association, which is an organization of lawyers, it's not a federal agency. So the more time between charging a trial also negatively affects the witness's ability to call important details of an event, which can adversely affect testimony. So the longer the delay, that's the whole point in a nutshell that I was talking about earlier, that people might not show up. So the time from arrest to trial frame, look what it says. Outside the mandated number of days outlined within the act itself. If it's a state case, it's going to be based on that state's Speedy Trial Act. If it's a federal case, then it's going to be in federal court, it's going to be the Federal Speedy Trial Act. And you can look that up and it'll tell you exactly what that is. But it says there is no universally accepted number of days between when a defendant is arrested and a trial has to start. That's what I was trying to tell you earlier. Okay? Because of so many things that happen within the system. They give an example in Wisconsin. An arrested and jailed person must appear in front of a judge or magistrate within 48 hours. You hear a lot of that in other jurisdictions too. A preliminary hearing to determine whether probable cause has to take place within 10 days if they remain jailed, or within 20 days if released. So the key thing is that the Speedy Trial Act in the Constitution is the foundation for the legislation in jurisdictions all over the country, each state, that they have fair and timely ways to deal with trials. Very, very critical. Any questions about the speedy trial? Any questions? No questions? Okay, good. Okay, just understand how it works. Here's a good article. Let me make sure the link is working, because I do know it's a good article, because I know about how they got that in there. Let me see if it's there. Take time. Yeah. Okay. Okay. This lays out the federal aspects of it, so you can take a look at that. Okay. But remember, I want you to learn about the Speedy Trial Act in your jurisdiction. Okay. So the Sixth Amendment trial rights, we deal with the speedy trial and the right to attorney. Those are the dynamic duo that has to do with the Sixth Amendment of the Constitution. Okay. And you have to be able to know what the charges are against you, confront witnesses, obtain witnesses in your favor. They're all in the Sixth Amendment excerpt here. It says, in all criminal prosecutions, to be informed of the nature and cause of the accusation, to be confronted with witnesses against them, to have compulsory process to obtain witnesses. Do you know what compulsory process is? Anybody know? It's something that Steve Bannon is disobeying, if you know anything about that, except it's in Congress though. Do you know what that compulsory process is that's used to compel people to come to court? What's it called? Anybody know? Yep, that's it. And if you if you it's a subpoena. So if you come to court and you are asked to bring documents, usually, or items, they issue what they call a subpoena ducis tecum. That means not only do you come, but bring what we specifically will ask for in the subpoena with you. So, all right. So that's pretty much how it works. So now, so you start out these cases with the and I'm not talking about the arrest itself, but a complaint is filed, and the complaint lays out the charges, and they have to indicate in the charges probable cause. And remember, it's a standard that's needed for arrest and is less than beyond reasonable doubt. That's what's required to convict. So probable cause means what it says. They probably did it, but you can't convict on that. So therefore, you have a trial, or a person, as I say, plead guilty. Let's talk about the trial aspects. Then the person must be found guilty beyond a reasonable doubt. Okay, that's the standard. And they'll look at the reports that are prepared, the charges that are filed, and if the prosecution does not believe probable cause exists, they may decide they won't charge the defendant and order them released and dismiss the charges. If adequate probable cause exists, the prosecutor will draft a complaint, present a copy to the court and the defendant. They can't have a field day with that, because there is a problem involved with repeating that, because then that comes up and bites them later, because that can come up as evidence in the trial if it ever goes to trial. So just like a search warrant, two parts. You have the complaint, and then you have the affidavit. The affidavit supports the allegations in the complaint, and it says it contains facts that will provide probable cause. That's it in a nutshell. So once this is filed, then if probable cause exists to hold defendant more than 48 hours and until the court appearance, the only exception to the 48-hour rule is if the prosecution can demonstrate the existence of an emergency or extraordinary circumstance to hold the defendant. That's not very often happening, trust me. And it's not it's a serious burden on them. If you read this, you'll understand why. Okay, so when the initial appearance, the court, as it says, will not make an official determination related to probable cause. Rather, they provide the defendant with a copy of the complaint, advise defendant of their right to counsel, and then determines bail. That's the key. And then schedules the next court date for either a preliminary hearing or arraignment. Why would it not be a preliminary hearing or arraignment? If it goes to the grand jury and the grand jury decides to vote a true bill, then it goes to arraignment. And I already told you what arraignment is. Okay. And then as it says, the official findings of probable cause occur at a later hearing, and that's a preliminary hearing or probable cause hearing if it comes about. Excuse me. We have oftentimes, as defense attorneys, had judges who want to deny a preliminary hearing, but we ask for it and we demand it as a constitutional right. We could use that as an appealable error in some instances. So what we're doing as lawyers, defense lawyers, is setting a record, making a record. And what we're doing is all along the way, we're getting information to provide a defense for our client, but at the same time, we're also making sure that the record reflects what actually takes place at the trial level or pre-trial level, so that when we do and if we have to file an appeal, we can use the transcripts and records there. As a good lawyer told me once, and he was my mentor, and he became a judge and then an appellate court justice in Illinois, Eugene Fincham, said, if it ain't on the record, it didn't happen. That's it. So you're not able to put that in unless there's some exculpatory information that comes out. And exculpatory is what we call escape material that the prosecution withheld if they knew that it would not favor their case. Okay. The defendant will be afforded their right to examine the witnesses and present them on their behalf. So then we have the right to cross-examine witnesses. My favorite thing is to have witnesses brought in under oath and question them. If you paid attention to My Cousin Vinny and or Legally Blonde, you saw how important cross-examination was. In Legally Blonde, the cross-examination by that young lady, Elwood, under the supervision of an attorney in court, because she was not a lawyer at that time, established that the witness on direct examination, who was the young girl, had provided false testimony, and she was impeached at the end by getting her to admit that she pulled the trigger and shot rather than the defendant. Now, that's a Perry Mason type thing. It doesn't happen very often. But what does happen is the other part is going to My Cousin Vinny, is when the attorney will generally try to prove that the person, whatever they said they saw, or the person they identified, couldn't possibly be the same person that is sitting in the defense chair, and that they would not have adequate time. Such as, if you remember, there was a female, black female, who had glasses, real thick glasses, and he proved that she could not have seen that even at half the distance. And so it put doubt in the jury's mind that she saw the right person. Remember the guy that said that he had leaves and dirty glass and all of that, weeds, all kinds of things blocking his view. It couldn't possibly have. And my favorite one is the grits one. Now, the point about the grits was that the amount of time that he claimed that he was doing what he was doing couldn't have happened because he was using real grits and not, as he himself said, no respecting, self-respecting Southerner would use instant grits. The point of the matter is that all these people were impeached, and that's a valuable part of cross-examination. I loved cross-examination. I love cross-examining as police officers. I think I talked to you guys, I don't know if I did, about I won a case because the police and the witness said that an incident happened on April the 31st. Did I talk about that in this class? Did I talk about the April 31st case? The person said my client committed the crime. Okay, here's how it went. The prosecution had alleged, and they put it in, and it was in the police report, and the witness testified that my client committed the offense on the 31st of April, and that they were positive about that date. Well, the police officer had it in his report written that way, and so I questioned him in the court in front of the jury about that 31st date of April. He says, oh, well, actually, that might not be the date. And I said, thank you. And that was it. But he wanted to try to explain it. The prosecution wasn't going to come behind, said no further questions, and let it alone. So let's spin ahead to, I went through several questions with individuals. And then what happened, guys, is this. When I got my closing argument, I summed up my case. But one of my highlights in this case was because the witnesses, the state, through the police, and the complaining witness was clear that that was the date it happened and the time. I said I learned a poem when I was a kid. And I said the poem went like this: 30 days has September, April. April. Did you hear what I said? June and November. All the rest have 31, except the month of February, which has 28 and 29. And I repeated that to the jury. Guess what? I won. And one of the things they said was, you all kept pushing on the 31st. How do we know if you weren't right on that date that this was not the right guy? Because reasonable doubt had been planted. You see what cross-examination did? You see how it worked? Everybody see how it worked? Y'all don't see how it worked? I don't see anybody saying anything. Well, the truth of the matter is, because we got to move on. But that's what happened. The impeachment. I brought it up on impeachment, just like L. Woods, just like um, Vinny did, the attorney, Mr. Gambino, and that things. So anyway, these are rights that are used in techniques that give the defense a chance to uh, make the state put on their performance that they can prove beyond a reasonable doubt that the person committed the offense. And so both sides present witnesses. And the Sixth Amendment, it says that the complaint is used in the court, notifies the defendant of the charges. And then the right to counsel kicks in that. So, okay. Any questions about any of that? Okay. Okay, make sure. No questions? I'm done. You do the knowledge check on your own. You're over. And you just go through this. Which statement is an example of a clear invocation of the right to an attorney? Maybe I need an attorney. I want an attorney. I don't know. Should I get an attorney? Do you think I need an attorney? Which one is it? Better know it. Yep. The request must be expressed, must be clearly expressed. Vague references will not work. So anyway, you can do one more. Whoops. Number 2. What is the correct application of the 2-week rule? An in custody defendant requests an attorney was released and interviewed again after a fresh Miranda warning was waived. An in custody defendant wanted to remain silent and cannot be interviewed. An in custody defendant has requested to remain silent and can be interviewed again after 2 weeks. What's the correct application? A, B, or C? Which one do you think? Which one? Anybody? Want to try this? There it is. The two-week rule only applies when an in custody defendant has requested an attorney, and so forth. Fresh Miranda statement must be obtained. Okay, so go over that and study that. Okay, we got to go. We got to come back. So, any questions, real quick? How about the key phrase? How about the key phrase? There are two real possibilities. Which one is it? No, but you're on it. You're close to it with the Sixth Amendment. There it is. Hold it. Back up. Brian got it. Different spelling of counsel, by the way, COUNSEL, but it's speedy trial. Speedy trial. You don't have to put S. It's speedy trial. So it's speedy trial. I don't care. So give me speedy trial, and you get your points for week number 5. I'll see you. I'm going to say the end of week 5 for the lecture and the assignments. Remember when they are due. So I'll see you in about 20 minutes from now with week 6.